standing by criminal defense attorneys Joe Tamburino and Greg Brenner. We have time for a little bit of analysis before we go to break at the top of the hour. And just want to ask you, gentlemen, how you see this case, if you see it as more of a state's case or as anybody's case. Joe, I'll go to you first, please.
Thank you. Yes, like we talked about before, you've got to start winning your case on opening statements. The way I see this case is it's a circumstantial evidence case, and it's going to all be up to state of mind. And remember, in Missouri, you can convict even on a life sentence based on circumstantial evidence. But this is really going to be about mental state because, let's face it, he could get up on the stand, the defendant, and say, hey, I just lost it at the end, and try to shoot for what's called an involuntary manslaughter or a heat of passion manslaughter. That's allowable under Missouri law.
Yeah, great point. Maybe he will take the stand and testify in his own defense. We shall see. Greg, your thoughts on whose case this might be, please.
I agree with everything you just said. And, if he does take the stand, that's the goal. That's the only option he has right now is for defense to try to get a lesser included. Maybe say that it was done in the heat of passion, something that will take it away from a premeditated killing. But that's going to be really tough to do. He talked her there on the phone for 22 minutes, and he had a gun with him. I don't know if there's going to be any testimony on whether he carried a gun or normally had a gun. But it's a tough road. It's a tough road. I mean, this guy, Mr. Addie, has told so many lies to so many people. He could be a politician at this point.
Point taken. Point taken, Greg Brenner. I have to say goodbye to Joe Tamburino. Joe, thank you so much. Greg's going to stay with us. We'll be right back with more live coverage and legal analysis of this next big trial we're covering for you here on Court TV.
I am confident that the evidence is going to show you that on April 27th of 2018, James Addie made a choice between his two lives. And I am confident that you will return the verdicts of guilty of murder in the first degree and armed criminal action for the death of Molly Watson, the life he did not choose.
Very good Monday afternoon to you. Thanks so much for being with us here on Court TV Live. I'm your midday host, Julie Grant. We are in Missouri today. We were covering the case of the state versus defendant James Addie. You just heard a little bit from the prosecution in their opening statement. Both sides really kept their statements very short, sweet, and to the point for this jury. The defense went a little over 5 minutes for their whole opening statement. And we want to show that to you now. Let's take a listen to what the defense presented to the jury today.
Fill in the gaps. That's what the state of Missouri is going to be asking you to do. Not connect dots, not listen carefully, but fill in the gaps for the state. Because the evidence will show that the state does not have proof beyond a reasonable doubt in this case. The evidence will show that yes, Jim had an affair. Jim had an affair with someone he actually loved. The evidence will show that because he had that affair, law enforcement jumped to a conclusion before knowing all of the relevant facts. Law enforcement jumped to a conclusion before knowing how Molly died. Within 6 hours of her body being discovered, without knowing without knowing an infinite amount of potentially relevant information, they jumped to a conclusion because Jim had an affair. The evidence will also show that Jim cooperated. Investigators went to his home that evening. He spoke with them. He volunteered the cell phone. He said, yes, I've had an affair. I have this separate cell phone I use just to contact her. He told them where he was. He told them what car he was driving, and they said, well, we don't see that car. And he volunteered, it's in the garage. Sure, go take a look. Consents to searches, cooperates, speaks with police. The evidence will also show that wedding planning was going swimmingly, that he was participating in the wedding planning. In fact, on April 27th, Jim paid $4,000 of the remaining balance. He participated in the wedding planning, he was still paying, he was dropping off decorations, and that's where the state's case makes no sense. This is again, there's a wedding website. It's a publicly available wedding plan. Been planned for almost a year. And that's the alleged motive? We were talking of what Emma Addie would say, Jim's daughter. She'll also tell you that what he did that evening was normal. That when he came home, he would do laundry, he would take a shower. Nothing out of the ordinary. We're here talking of the perfect tire impression. And you'll hear testimony about how these tires are evaluated, ostensibly trying to be matched with a plaster cast taken in the field. But what you will also hear is that there is no science in this practice to speak of. There are criminalists who get training and looking at two things next to each other and saying, aha, in my opinion, these things are a match. And it's their opinion that apparently matters. There's no scientific standards. There's no data. There is nothing to consider this scientific evidence. And at the end of this case, I'm going to get back up here, confident that you will find Jim not guilty. Because the state will be asking you to fill in the gaps because it does not have the evidence. Does not have the evidence. Putting Jim there. It does not have the evidence that this makes any sense at all. I will come back confident that you will find him not guilty. Thank you all.
So what did you think of the defense open? Let me bring in our legal analyst guest to see what he thought. Criminal defense attorney Greg Brenner is still with us. All right, Greg, give us your analysis if you would, please.
I think that he's up against it with this one. I think that when you have a client who's looking at a first-degree premeditated murder charge down by a creek bed, you better not use the word swimmingly in your opening statement. That's a big gaffe and offensive, quite frankly. But, you know, he's talking about the state needing to fill in gaps. I think that there are many gaps that seem to already be filled. And this looks like a situation to me where the jury is going to just need to look at the evidence and use their common sense.
Mm-hmm. You know, I like that he was very confident as an advocate. I liked how confident he appeared. Don't know that the facts are really on his side. Don't know that the confidence really matches the facts that are alleged here. I love the point you just made about the word choice, how that's really problematic. I like that you pointed that out for us, Greg. Tell me, if you were defending James Addie, what would you have perhaps done differently at the outset in opening statements?
I might not have laid out the roadmap that was laid out. I might not have said, made statements that then you would have to show corroboration in the future, because if they're not able to do that, that's going to be a problem, and the jury is going to be looking for that. That could be a potential gaffe.
Right. How about in terms of whether or not he should testify? Obviously, that's a huge question in every criminal case we see. We know that rarely defendants help themselves, but sometimes they do. What do you think here? Do you think he has anything to gain by taking the stand?
You know, I'm not sure that I have every piece of evidence to be able to answer that question. And in so many cases, you're right. The last thing a defense attorney wants to do is see his or her client get up and take the stand. But first of all, it's a decision that's not up to the attorney. It's up to the client. But secondly, in this situation, we might have an incident here where if he doesn't get up and try to explain why it's not this, it was this, he might be in trouble. In other words, the best defense might be, hey, yeah, it did happen, but it didn't happen because I intended it to happen. It didn't happen because that was my plan. I had no idea that was going to happen. It happened because this, that, or the other happened in the heat of the moment, like I said earlier. And if that's going to be the defense, then there has to be evidence of that. And the only way to put that evidence up is going to be for Mr. Addie to take the stand. Period.
True. Tell me, what do you think of his appearance today? We know optics always play a part in any criminal case. The jury's watching to see how the lawyers look, how the defendant looks. In terms of appearance, we see him in the dark suit today. We know he's got the mask on. Share your thoughts about that. We were just showing a little bit of video of him, and perhaps we could put that up again. What did you think of how he's dressed today, Greg?
He's dressed fine. I like to have a client maybe in a tan suit or a lighter suit. I think it's a friendlier color, but he's not going to win or lose this case because of the suit and tie combo that he's wearing. I bet he's glad he has that mask on right now and can hide a little bit from the jurors and the alternates that are sitting there staring at him. But he's doing okay with this suit game.
I was just going to ask you if you thought the mask was helpful, and you sort of answered that with your last answer that, yeah, in his case, perhaps it's a good thing he has a mask on right now.
Yeah, I didn't see there, but I wonder if he has a yellow legal pad that he's writing down brilliance on, or thoughts or questions that he has for his attorney, or advice.
Yeah, perhaps. We'll see. We'll get another look at him when the jury comes back, which is supposed to be any minute from now. Greg Brenner, great to have you with us on the program. Thank you kindly. We're going to step aside for a break. When we come back, we'll continue with our live, uninterrupted coverage of Missouri versus James Addie right here on Court TV.